while doing so, while doing so, there was a clear intention behind the legislature to exclude the gaming, wagering or betting. And by introduction of section 11, which is nothing but a savings clause, saving the game of skill, which reads as nothing contained in section 5 to 10 of this act shall be held to apply to the games of mere skill wherever played. So therefore, way back in 1930, there was a clear distinction between game of skill and game of chance. A game of mere skill, wherever it is played, it stood excluded from the ambit of gaming. So therefore, even when you stake, when you bet, there is a distinction. The substantial degree of your skill played a game there, and therefore that was excluded from the ambit of gaming way back in 1930. Now, between 1930 and 2023, there's 90 years, certain legal jurisprudence had been settled. Now it is imperative that one has to look into uh, the judgments of RMDC 1, 2, KR Satyanarayana, and so on. I'm not going to get into the legality. I mean, I'm not going into the factual aspect of how these cases turned out to be a bedrock of jurisprudence way back in 1930 for about 6 7 decades. But it would be right on my part. It would be wrong if I don't touch upon the very basic fundamental factors that defined this gaming jurisprudence. Now, the first of the case is RMDC1, RMD Chamar Bagwala versus the state of Bombay versus Chamar Bagwala, where they interpreted the word betting and gambling as seen in entry 34 list 2. Prior to the pre-GST era, there were two entries. Entry 34, which dealt with betting and gambling, and entry 62, which dealt with taxes on betting and gambling, apart from entertainment and all that. So the question that arose before for consideration before the court, or the High Court of Bombay, and which travelled up to Supreme Court, was whether the amendment to the Bombay Lotteries and Prize Competition Control and Tax Act would also cover the innocent prize competition. Now, before we get to know what actually is entry 34, entry list 2, and all that, the assessee in that particular case was incorporated in the province of Bombay, and he had a lottery a prize competition which was governed by the Bombay Lotteries and Prize Competition Act in 1939. And he renewed his license, and there was, while renewing of license, he came across some difficulty, and therefore that could not be renewed at all. So he had to shift his company to the province of Mysore, where Mysore Act was dealing with the Price Competition Act and all that. Now, what this SSC did was he again got hold of the Mysore registration, and he was getting this all these game competitions by way of RNDC crosswords. Now, a pertinent question arose where when the Bombay Lotteries and Prize Competition Act saw certain amendments in 1948, in 1952, and consequently the Bombay Competition Control and Tax Act Rules 1952 came to be enacted, where they say, boss, whether you reside here or not, if your game comes into my state, whether you print it here or not, it is taxable. Now, there arose the question, and immediately the challenge was made before the Bombay High Court. The Bombay High Court laid down certain principles. For the first time, the doctrine of res extra commercium was brought in by Justice Das, where you all know, for a minute, you all know what doctrine of extra commercium means. In common parlance, it means things that fell outside the commerce, trade commerce. It fell outside the commerce. So therefore, the Price Competition Act was looked into. There were five different categories of price competition, and one of such was this crossword puzzle. So therefore, ultimately coming to a conclusion that the Bombay High Court, the Supreme Court ultimately came to a conclusion that the applying the principles of res extra commercium, that this act fell outside the concept of the commerce, and therefore it is not protected under 191G. But otherwise, uh, there was no distinction between game of skill, game of chance, and all that. The second of the case was RMDC 2, which again reiterated the price competition, And the question that was decided before the Supreme Court again was whether the Prize Competition Act 1955 covered even competitions where substantial skill was involved. Now it's a case where Section 2D of the Prize Competition Act, which defined the prize competition, whether it would embrace the competition, the success, the dependent on success is by chance or by skill. The Supreme Court again The Supreme Court again held in the case of the SSC by saying that this fall outside the scope of this res extra commercium. And thereafter, one more case by the name case Satyanarayan was came into picture, where where these two cases were not discussed in toto, or no, not even a passing remark of these two cases were dealt with in KR Satyanarayana. But ultimately, the KR Satyanarayana case was dealt with the case of Rummy. It's a case where when you play rummy, whether it the game entirely relies on the concept of chance, like the three game card like flush and all that. The court ultimately held that the rummy is a game of chance and therefore there is no skill involved in it. Now these are all the basic factors that needs to be looked into before we come into the facts of the jungly before the Madras High Court. In 2021, after 90 years, in 2021, the Madras High Court, the Tamil Nadu legislation 1930 Act was amended in 2021 based on the public policy. Now, by which time, right after COVID, we were all stuck inside the house and all that. We were absolutely, we had nothing to do. The only way of whiling away time was either to read, which people did not, and to play rummy or online games, which people involved in it. So therefore, the problem occurred when people stake money, they lose money out of chance, and there was no absolutely skill involved in it. So therefore, the government of Tamil Nadu proposed this amendment in 2021 based on the public policy. They got some law commission report. They had appointed a commission to ascertain as to what is actually happening in the state of Tamil Nadu and how this the gaming by way of wagering and betting could affect the people in toto. And on a broad senses, by taking by interviewing two lakh plus teachers, they said that there is a substantial change in the mind of people and they are committing suicide, and there is a threat to life by waging betting in the game of lottery, or by staking money or money's worth. So people obviously lose. If you put 10 rupees, you wait for 100 rupees, but you end up losing this 10 rupees. And so therefore the government came out with a policy by inserting section 3A. Now, this 1930 Act was totally replaced. The gaming definition was replaced in 3A, where they say, with the advent of technology, they also brought in the ambit of cyberspace using computer system and all that, where you wager or bet. And they also specifically brought in clause 2, where they say, where they make some remark about playing rummy poker and organizes any such wager or bet in cyberspace shall be punished with imprisonment. While doing so, they amend Section 11. The earlier Section 11 was a savings clause where the game of mere skill, wherever played, was excluded from the ambit of gaming, be it betting or wagering or betting. But by this amended 19 Section 11 in the 2021 Act, they closed the entire issue in toto. They say this Section 5 to 10 shall apply to the games of mere skill if played for wager, bet, money, or other stake. Now, this was challenged before the Madras High Court, and the councils before the Madras High Court placed the reliance on doctrine of proportionality. And they say that the word gaming has a long-standing jurisprudence that was not considered, so therefore the word gaming would be nomen juris, and that the entry 34 should not restrict the state legislature, the legislative power of the state, the legal competence of the state should not restrict everything based on the public policy. Now, the Madras High Court, while dealing with it, at para 107 had specifically dealt with. The wording of the amending act is too crass and overbearing that it smacks of unreasonableness in its every clause and can be seen to be manifestly arbitrary. Whatever may have been the pious intention of the legislature, the reading of the impugned statute and how it may operate amounts to a baby being thrown out with the bathwater and more. And irrespective of the noblest of intentions, the effect of the provisions of the impugned statute is the primary consideration for assessing the validity thereof. So, therefore, the Madras High Court struck down the amendment, saying that it does not fall within the legislative competence, and thereafter the matter went to the Supreme Court. Now, parallelly, the Karnataka High Court had the same issue where the Police Act they brought in the ambit of the gaming within the definition, and they had to come to the Supreme Court and knock the doors of Supreme Court. And Supreme Court, while dealing with the decision of Janvi, found that there is a common thread between both the High Court of Madras as well as the Karnataka High Court, which is nothing but the entry 34 of list 2 of the Constitution, Schedule 7 of the Constitution, and its legislative competence. The Madras High Court solely premised its position on doctrine of proportionality and also held that the word betting and gambling cannot be divorced. It said it should be betting on gambling. It cannot be betting and gambling that has a legislative competence to bring in that the game of skill and game of chance could not be distinguished, or there is a distinct difference between game of skill and game of chance. While doing so, the Madras High Court had followed the jurisprudence laid down in RMDC 1, 2, KR Satyanarayana, and all that, and conclusively held that it is not so. Now, before the Supreme Court, how the Supreme Court dealt with all these amendments and what the Supreme Court found and what Supreme Court found it, how Supreme Court found it wrong. As I as I told earlier, that the only common thread before the both the Madras High Court as well as the Karnataka High Court was that the entry 34, whether you read the entry 34 with the conjunctive clause and, or you replace the word and by on. And the Supreme Court shut down the issue once for all. It said, boss, if you're going to replace the word and by on, this will give irrational meaning. Before dwelling into all this, Supreme Court, with their fresh eyes, they unsettled the jurisprudence that was laid down, that was a bedrock for almost 6 7 decades in RMDC 1, 2, KR Satyanarayana, and all these three cases. And there are a number of plethora of cases that was distinguished by the Supreme Court, or that was uh, given revisited, or the decisions have been re-examined by the Supreme Court in a way to adapt to the technological advancement vis-a-vis the public policy that was the main fabric for these legislation to be enacted. Now, the Supreme Court on demolished the reasoning on multiple levels. The first is that the exercise of constitutional construction, the word, the phrase betting and gambling to be replaced by betting on gambling was not permissible exercise as per the constitutional construction. Supreme Court said, in other words, it is rewriting the constitutional text. The expression betting and gambling it derived from the jurisprudence across the globe, and Supreme Court had drew analogy from different entries from the Schedule 1, more specifically entry 48 of Schedule 1, where Supreme Court which the Supreme Court uncovers as to what is stock markets and future markets, and whether this constructive conjunction could be dealt with the way that the SSC looked into, whether betting on gambling could be read, whether it will give a rational ending or it will be a rational irrational ending, is what the Supreme Court ultimately laid down. The second thing that Supreme Court laid down was that all these years, the old jurisprudence in RMDC 1, 2, and Satyanarayana and MJ Sarin had been misread. Now, Supreme Court had specifically dissected these cases separately, uh, running about 10 to 12 pages on each cases as to what was the Taraka Mantra behind these cases and how the Supreme Court saw this with a fresh eye. For example, while dealing with RMDC 1, the Supreme Court said that the issue was pertaining only to simpliciter. The issue was whether the Bombay Lotteries and Prize Competition Act extended to innocent competitions involving substantial skill. The dispute turned out to be with respect to entry 62 of this 2, where they say tax on the betting and gambling, and not the word actual betting in entry 4, which deals with betting and gambling. So this was the first distinction that Supreme Court said was you will all have been reading the decision wrongly. The second of the case is RMDC, so RMDC 2, where the Supreme Court said again the competition, the question that was involved in RMDC 2 was the severability of the Prize Competition Act and its application to skill-based competition. This was the factual scenario before behind the players taking money on a skill. Uh, Therefore, authoritatively concluded, the Supreme Court concluded that the betting and gambling is not synonymous to entry 62 of tax on betting and gambling. It should always be read as betting and gambling and not betting on gambling. Now, while dealing with K.R. Lakshmanan, the Supreme Court said at least those two cases had dealt with or some iota of difference or some thread as to the competition act and the entry 34, but this is the case where you deal with horse transaction, horse racing vis-a-vis the Madras Police Act, and therefore this carves out this carves out from the protection of games including skill. So therefore this K.R. Lakshmanan cannot be looked into at all because this is entirely on a different facet. The third most fundamental thing that the Supreme Court uh, dealt with was the question merely is whether uh, the game rummy is whether a game of skill. If yes, the activity is protected under 19(1)(g). If no, can the state regulate it? This is a simple question before the Madras High Court as well as the Karnataka High Court. The Supreme Court rejected this framework in toto. They say it is not about the game, it is about the wager. The Supreme Court, while dealing with this aspect, had said that the platform that Mr. A, that is the Jungly game, provides, has a wallet to it. So there is no such participation fee as how you enter into a horse race course. When I have to play the game of rummy or jungly or whatever be it, I'll have to go by paying some amount which is construed to be a participation fee, but the nomenclature though that seems to be a participation fee, it cannot be a participation fee. It is the right for you to play the game. So if I stake 10 rupees, 200 rupees is the amount that needs to be put in the wallet. Now this 200 rupees, four people will do. Now this wallet, now the action of you staking money would end the game once for all. The Supreme Court said you need not harp much on as to whether you involve skill, what is the substantial degree of skill, is it extensive, is it narrower in scope? Boss, let us not go into all that. Simple fact is that you ask yourself whether it is a game of skill or game of chance. Game of chance, game of skill, say for example chess. It involves game of chance, game of skill. What about rummy? Though it involves substantial degree of skill or to some extent 40-60% degree of skill, it always transpires, it always traverses with the game of chance. You don't know the outcome is uncertain, so you're expecting, you're by putting 10 rupees, you're expecting an uncertain outcome by which you may earn a higher price of 300 or 400. So therefore as soon as the concept of you the as soon as Mr. A stakes money on anything, there ends the game. So therefore let us not go into whether betting is there, gambling is there, betting on gambling, betting and gambling. The moment you put the stake in the wallet, there ends the game. There is no prohibition, there is no other word. And the Supreme Court merely demolished all these aspects and say yes, it has the legislative competence. Now when money is staked on an uncertain outcome, The act of staking itself constitutes betting within the meaning of entry 34 is what the Supreme Court has held. The character of the underlying game is relevant only when a statute expressly extends the protection to a game of skill. And here, in absence of such protection, the money you stake, the moment you stake the money, it ends the game. Now, while referring to all these things, both the Madras High Court as well as the Supreme Court referred to the Constituent Assembly debate on the very same betting and gambling that happened way back in 1949. Now one of the contention in the Constituent Assembly, I will read that. A member objected to the government's attempt to ban rummy, describing it as harmless game. Sri T.T. Krishnamachari responded directly that the Bombay government's order was aimed precisely at prohibiting rummy because of the stakes involved, and because when people play this game for such high stakes, it takes the form of gambling. Now, here is where Dr. B.R. Ambedkar intervened. Now, B.R. Ambedkar, he drew distinction dealing with entry 45, saying that the moral grounds includes legalizing gambling. Now his response was unambiguous. Dr. B.R. Ambedkar's response was unambiguous. He said, without the entry, the provisional governments would be absolutely helpless in the matter of controlling betting and gambling. You will have to bring that into the ambit and leave it to the competence of the state legislature to deal with it. It is for the state's headache to prohibit it, restrict it, ban it, or happily go away by it. This is what the forefathers of the Constitution of India had a debate in 1949 and ended it. The Supreme Court, though Madras High Court had a passing remark over it, Madras High Court did not really dwell on these aspects, but the Supreme Court said the forefathers, especially Dr. B.R. Ambedkar's intention was to remove this, was to keep this intact in the entry 34 under the scope of betting and gambling, so that the states has the legislative competence to deal with it, either to prohibit it, restrict it, or play the game on some regulations. Now, coming to the um, aspect of res extra commercium, which means that things outside commerce. um the gaming industry's position had always been that because their platforms facilitated skill-based games, they were engaged in lawful trade, and therefore they are rightly protected under Article 19(1)(g), and therefore res extra commercium is applicable only to chances, pure chances of pure game of chances, and not pure game of skill. Now, Supreme Court negated it in toto by again coming back to one form, saying that boss, when you stake it, the outcome on an uncertain outcome, there ends the game. The Supreme Court again, while dealing with this Norman juris, it said the constitutional entries in entry 34 as well as in entry 62, they dealt with betting and gambling and not gaming. So therefore, the word gaming is not normal juris. It is only that we'll have to look into the aspect and the intricacies and the scope, whether it is wider or extra wider or narrower in terms of the definition, betting and gambling. And while concluding this, the Supreme Court dealt with the public policy as I already uh, de- dealt with. They took the test of even tempo of life, which is parameter of the concentric circles doctrine, and which only says that there are three different things: law and order, governance, and security. And Supreme Court ultimately said that when you are to place entry one public order, it prevails over the other entries. You cannot just negate this public order when there is an actual threat of security where your own people, bunch of people are committing suicide. So the morality has to come first, and the legal competence has to come second when you are dealing with public order. So therefore, the entry one public order prevails with the other entries, More concerning is that the Supreme Court dealt with the preamble of the Tamil Nadu Amendment Act 2021, where they had a very long interview, and the census of from the teachers, 2 lakh teachers, as to the life, the threat of life in terms of the betting and gambling that has been conducted in the state of Tamil Nadu by online rain gaming. Now, as far as this jungly is concerned, the Supreme Court has closed down the issue. To be very precise, once you take this money and stake it on an uncertain outcome, there ends the game. The state's legislature, the state has the legislative competence to do whatever be it, and it squarely falls within the Article 34 betting and gambling, which is wider. All the entries in the seventh schedule of the Constitution has to be given wider and liberal connotation, is what the Supreme Court held. Now, the taxability per se of the GST is more specifically dealt with the Gamescraft tech. Now, Gamescraft technology is a case where it emanated from the Karnataka High Court. The SSC before the Karnataka High Court was issued a show cause notice under Section 74 on account of fraud, willful misstatement, and suppression of fact, on the premise that they had termed the supplies, they had misclassified the supplies as services taxable at 18%, and it should have been taxed at 28%, and they wanted to recover the amount. So that's how the Gamescraft decision emanates from the Karnataka High Court. And ultimately, the Supreme Court at the outset said that the actionable claim, the supply of service, is actionable claim, and closed the issue once for all. But before doing that, the Supreme Court drew analogy, or rather, the Supreme Court derived the judgment of the jungly and placed it into the judgment of the Gamescraft. You cannot decipher, you cannot go away without touching upon jungly, is what Supreme Court says, because the very basic mantra that whether betting and gambling, whether game of skill or game of chance, it has a distinction. Whether that could be prohibited, banned, or not is answered by the Supreme Court. Supreme Court has given a green light saying that there is a legislative competence of the state to do whatever be it. So therefore, deriving that, the first of judgment in Jangli was authored by Justice Paddiwala, and this Gamescraft, running about 417 pages, was authored by Justice R. Mahadevan, where he derived the analogy from the Jungly decision. For about 30 to 35 pages is the extract of the Jungly judgment, and how he says and how he looks at the old jurisprudence, bedrock of jurisprudence, which paved way for the online gaming industry for about 6 7 decades, and how he looks it in a fresh eyes on his own to say that this is distinguishable from the present case. Now, the argument before the Supreme Court, before the Karnataka High Court by the Revenue, was that the Gamescraft is purely on online rummy. So they say that when you play stake again, it amounts to betting and gambling. So therefore, it is a good. They say it's an actionable claim. No, it doesn't say actionable claim. Karnataka High Court is prior to amendment. It is way back. It is rendered in the month of May 2023. The amendments were brought in October 23. I stand corrected. The petitioner before the Karnataka High Court uh, said that the game of Rummy is played in a platform which is a game of pure skill and is not a pure chance. This was rejected by the Supreme Court. But before the Karnataka High Court ultimately held that the game of skill, Rummy, is actually a game of pure skill. It is not a game of pure chance. The Karnataka High Court again got into the concept of res extra commercium. It said there is sufficient jurisprudence to show that lottery, betting, gambling will be seen as noxious and per se classified as res extra commercium, as beyond commerce. But while doing so, the Karnataka High Court harped on the concept of supply. It said the GST is levied solely on the concept of supply of goods and services, or both, and it also brought in a significant aspect that the import of good continues to be governed by the Customs Act 1962. So therefore, the interesting part is that the those supply of goods or services is essential to attract the levy of GST, there is no direct reference to the same in Article 246A. As we all know that the 101st Amendment to the Constitution of India brought in Article 246A. I'll just read that Article 246A. It's a special provision with respect to Goods and Services Tax Act. While the first clause has a very common parlance, the second clause requires attention. Parliament has exclusive power to make laws with respect to goods and services tax where the supply of goods or services or both takes place in the course of interstate trade or commerce, whereas clause 1 does not have the word supply of goods or services of interstate trade or commerce. So therefore simpliciter 240 by introduction of 246 capital A, the parliament, the constitution has given power that in respect of interstate supply, it is the parliament who can enact laws. And in respect of the intrastate supply, it is the union and state which can uh, create laws or regulate laws. Now, the Karnataka High Court also went on to the definition of business as contemplated in the GST Act. It says the business includes wager, advancement, trade, commerce, and any other similar activity. So, therefore, since the business definition of business includes the term wager, the Karnataka High Court said, "Boss, this may also fall under the phrase any other similar activity." So, therefore, this activity are akin to wager. And more specifically, Karnataka High Court again dealt with the concept of betting and gambling. They got in the jurisprudence of RMDC 1, 2, KR Satyanarayana, and ultimately concluded that betting and gambling as featured in the entry 62 of list 2 dealt with tax on betting and gambling. By this 101st Amendment, the entry 62 got subsumed into the GST Act, and it was only entry 34 that dealt with, and it is mere betting and gambling, and there is no concept of game of skill, or game of chance. And ultimately, the Karnataka High Court concluded that the section 2 subsection 17, which deals with business, includes the term wagering to mean lottery, betting, gambling as game of skills, and more specifically dealt with Schedule 3, Entry 6 of the GST Act, which deals with the actionable claims other than lottery, betting, and gambling. So this is the basis on which the Karnataka High Court had quashed it and said that the game of chance, whether played with stakes, is gambling. A game of skill, whether played with stakes or not, is not gambling, is what the Karnataka High Court said. Now, this Karnataka High Court judgment was rendered in the year 2023, May 2023. But before we step into the Supreme Court decision, it is imperative that a series of amendments was brought in by the GST Council in the interregnum period. Now, this roots back to the 42nd GST meeting and 47th GST meeting, where the group of ministers, there was deliberation on GST Council meeting. The question is extracted here: whether the activities of race course and online gaming amount to betting and gambling or not, in the light of various High Court and Supreme Court judgments, and how should the supplies of casinos, race courses, and online gaming be valued, whether on full face value of bets placed or on the gross gaming revenue, is what the question that was deliberated in the GST Council meeting way back in 2020-22. And in the meantime, in the 51st GST Council meeting, the amendment was proposed, which you can see that the amendments were a shocking amendment, that the entry 6 in Schedule 3 of GST Act was amended in toto. Earlier, the existing provision was the actionable claims other than lottery, betting, and gambling. And the amendment that was proposed is actionable claims other than specified actionable claims. And the by way of this amendment, the definition of lottery, betting, and gambling was brought in this definition of specified actionable claim under section 2 subsection 102a that was inserted in the year 2023. Specified actionable claim means actionable claim involved in by way of betting, casinos, gambling, horse racing, lottery, online money gaming. Now, there was no definition prior to this amendment of online gaming what actually means. Now, this provision was inserted under subsection 80A after subsection 80. Online gaming means offering of a game on the internet or an electronic network and includes online money gaming. Now, they also further define what is online money gaming. Now, online money gaming means online gaming in which players pay or deposit money or money's worth, including VDA, virtual digital assets, in the expectation of winning money or money's worth, including virtual assets. And they also insert the proviso to supplier, the definition of supplier under the CGST Act. Now, after the amendment took place, the Supreme Court, the challenge was to the definition of the goods, which included actionable claims. But before we step into all these, one should it is an undisputed fact that the definition of goods, as seen in the GST Act in section 2, subsection 52, which was introduced when the GST Act was enacted, it says goods means every kind of movable property other than money and securities, but includes actionable claim. So therefore, way back in 2017 itself, GST, the legislation was conscious that we should bring this definition of actionable claim into goods. But the Schedule 3, but the entry Schedule 3 to Entry 6 of CGST Act specifically prior to amendment deals with actionable claims other than excluding lottery betting and gaming. Now, by way of an amendment, these are all brought in a single ambit of specified actionable claim so that you cannot escape tax. So, in my opinion, what Supreme Court does it actually says, boss, it is already there. I am giving the seal of the court to say that yes, it is an actionable claim. But the interesting part of the Supreme Court's decision is twofold. The Supreme Court has negated all the constitutional challenges posed by the SSC. The one of the arguments, interesting argument of the SSC councils, were that when you refer to goods, you should get into the Constitution. Article 366 is the definition clause in the Constitution, which defines every single thing. If I may read section Article 366 for a minute, Article 366 clause 12 defines goods. Goods includes all materials, commodities, and articles. Now, if one has to step into how the Constitution has defined services, one cannot negate the definition of services in the Constitution. Article 366 26A, which defines services means anything other than goods. Anything other than goods. So therefore, if you go to services, they say, boss, it is anything other than goods. If you go to goods, they say it includes materials, commodities, and articles. Whether the supply of this platform, the supply of these generally game or the game craft, the platform itself would be an actionable claim is what the Supreme Court had interestingly dealt with and settled the issue once for all, saying that it is an actionable claim, it is a good, so therefore it is an actionable claim. Now, while Supreme Court dealt with all these, Supreme Court referred to the definition of actionable claim as seen in the Transfer of Property Act. Whether the act of betting and gambling includes supply of actionable claim, Supreme Court says from the definition. This is from the definition of Transfer of Property Act. It means actionable claim means a claim to any debt other than a debt secured by mortgage of immovable property or by hypothecation or pledge of a movable property or to any beneficial interest in movable property not in possession either actual or constructive of the claimant, which the civil court recognizes as affording grounds for relief whether such debt or beneficial interest be existent, accruing, conditional, or contingent. Now, the Supreme Court has dissected this into three different categories. Whether at all there is a debt, and secondly, whether there is a debt and there is a beneficial interest accrued to you. Yes, the answer is yes. The Supreme Court says. Second, whether the possession is either actual or constructive, and the third, is whether it is a recognizable right for me to enforce in law so that I can sue the person. The Supreme Court, the first, it says it is a beneficial right accrued to you. The moment you put stake to it, the moment you place money in it, you have the right to play it. And if you lose it, it is governed by a certain law of the gamescraft technology itself. There is an agreement to it, annexed to it. So all these activities are governed by the gamescraft or X platform. So therefore, there is no escape route for you to say that boss, I cannot escape this. I will have to only go and sue it. There is a debt created. There is a beneficial right, interest that is created the moment you stake money into it. The second is whether the possession is actual or constructive. The Supreme Court says yes, there is a constructive possession involved in it, and there is also an actual possession involved in it, because you don't know the outcome. The outcome is uncertain. As and when you play the game, until such time, the wallet is yours, though it is operated by the gamescraft or the X platform. It is yours. And the third important thing that the Supreme Court does is it says while you deal with the definition of actionable claim, you have to satisfy all the three ingredients. But you cannot say that all the transactions can be enforceable in law. Now, when you say that the third most important thing that Supreme Court says is there should be an existent, accruing, conditional, contingent interest on you, and it can be you can recognize before the civil court to file a suit against that. The Supreme Court said the moment you stake it, again it comes back to square one. It says the mantra is the moment when you stake it, there ends the end of the game. It is an actionable claim. But while dealing with as to whether it is a good or supply of a good or service, the SSE said that it is a service, supply of service, and it is not good. Supreme Court referred to the definition of goods vis-a-vis the technological advancement and say that you cannot construct or go into the aspect of Sale of Goods Act under the definition the Sale of Goods Act and say that how the decision of Supreme Court in Gannon Dunkley referred to, you cannot apply that here because there is something that is evolving here. Now, goods, it was way back, it was introduced way back when the constitution was there. Introduced goods includes all materials, commodities, and articles. So you cannot keep that. So that's exactly why the reason constitution enacted brought in 246A and gave the powers to the GST authority, the legislation, state legislation, or the parliament to enact laws and regulate it. So therefore, you cannot always touch upon the definition of goods in the constitution and say, boss, the constitution only talks about goods that are materials, commodities, and articles, and therefore I am not goods, I am service. The Supreme Court only says when something is not there, you will have to go to 246 capital A. 246 capital A says interstate supply, you deal with it, intrastate supply, you deal with it. So therefore, there is a specific special code which has to be dealt with. And Supreme Court again, it said while doing so, it rewrote the entire jurisprudence. It settled the position that RMDC 1 2 KR Satyanarayana would not be a good law anymore as far as the technological advancement in the online real money gaming is concerned. Now, the as far as the amendment in 2023, whether it is retrospective, it is clarificatory in nature or not, the Supreme Court again said to, in simple words, what Supreme Court said was something was already there in 2017 itself. Goods, the definition as per the goods under the GST Act had the word actionable claim. It is only that these fellows woke up and said that yes, boss, this includes specified actionable claim. So the intention of the legislature was already there existing in the pre-amendment existing stage itself. So therefore, the definition of goods which has the word actionable claim itself is enough. And the amendment brought in by way of section 252 or the rules in 31B and 31C is all clarificatory in nature. And therefore, the Supreme Court ultimately, when dealing with all these matters, said that the 2023 amendments it neither create a fresh levy nor introduce a new taxable event for the first time. The taxability of actionable claims arising from betting and gambling, as per the Supreme Court, stood already recognized under the pre-amendment statutory framework, um, and the amendments principally operate to provide greater statutory clarity as to what was then existing. And so therefore this rule 31b 31c is clarificatory, and the amendments brought in by way of the entry 6 in schedule 3 as to actionable claims, including the special specified actionable claims, is clarificatory in nature, and it is retrospective, and therefore it operates retrospectively is what Supreme Court says. And while closing this, uh, Supreme Court also says GST is a tax on supply and not on profits. We may draw analogy from the Income Tax Act. Section 115BJ of the Income Tax Act deals with the winnings, net winnings on the profit from the winnings. So therefore, Income Tax Act being a direct tax, it dealt purely it dealt purely with the net aspect. While the Supreme Court says GST, it deals with the taxability on supply. So therefore, it has always been the gross income. By doing so, Supreme Court says that the 10 rupees that each of the participant puts in the wallet, which comes up to 400 rupees, the gross value that needs to be taxed at 28%, and it is not the platform fee alone for which you've been paying 18% is the right thing, because the GST Act is clarificatory and which says that it is always the transaction value. Now, what is transaction here? Transaction is the amount that you spend there, that you stake there. So whatever the amount that is spent there, that is staked there, it goes to the wallet, RC wallet of the particular entity. So therefore, that gross value until the uncertain outcome is there, is remaining in your wallet. So therefore, the taxability remains on this gross tax value alone, and not the net tax value which you create, which you say that to be a platform fee. Now, what is the takeaway from all these? The decision of the Supreme Court uh, is that Supreme Court did not answer on whether it is amenable to invoking of Section 74. So, therefore, this being a mere interpretational issue, the concept of the fraud, willful misstatement, and suppression of fact may not arise, and for the adjudicatory authorities to decide as to how the rigors of 74 would get into picture. The second thing the Supreme Court did not get into, or I would rather say that we have a good case, or the SAC's litigation is open in respect of the computation and quantification. In the gaming platform, there is something called deploying an amount. It's similar to your FD, which on maturity you will say that it is again rematured. You will again say that we'll start from the next year afresh. So the term redeployment in the gaming aspect, say for example, if I have 5,000 rupees staked in the amount, and if I win the entire thing, I can redeploy this 5,000 rupees again for another game. So therefore, this 31B, it doesn't talk about the redeployment per se. So therefore, we have a the strong case on, or probably there is a box open, Pandora's box open for the litigants to litigate as to the computation and quantification of all these redeployment, because the court kept all the factual and computational objections open. The third most important thing is that when you ban something, there is no tax. When you tax something, there is no ban. So therefore, the insolvency aspect of this comes into picture. I see from the news that the Gamescraft or almost all the companies have already shut their businesses, and they are all projecting into a multiple business ventures now. So therefore, what about the amount that is crystallized already in the form of adjudication process? Now, the industry may witness an increasing number of gaming operators who were previously involved in the staking in the gambling business, in the money online real money gaming business, um, to explore insolvency and to restructure themselves. So, therefore, when you have to look into the GST aspect, you will have to also look into the aspect of the insolvency aspect also. The one thing that the legislature, in my opinion, could have brought in is that under the income tax act there is a specific the a specific issue that knocked the doors of Supreme Court was in the context of PFESI, where in the year 2015 Madras High Court and other high courts had dealt with the definition of relevant due date under the Income Tax Act, whether it means the relevant date of filing of return to 139(1) or the relevant PFESA Act. Now, the Supreme Court in Checkmate Services kept a check saying that, boss, it is only the relevant PFESA dates. So, therefore, the interpretational issue as to whether the relevant for the previous past proceedings, whether that would be a relevant date of the IT return or the PFESA relevant date is still hanging. Though it is not amenable, I am trying to connect this with the 74 aspect, saying that this may not be a question of fraud, willful misstatement, or suppression of fact. Though the legislature was conscious enough to bringing the word actionable claim under the definition of goods, and that the mechanism is being clarificatory in nature on GGR value, the full face value, there may be an issue of interpretation alone. This may not be a case of the department to invoke section 74 and 74 and tax you at 100% of the taxes, the gross amount. Now, at the end of the day, to sum up this presentation, I would only say that both these decisions, Jungly and Gamescraft, they have a common thread. Now, in my opinion, if Jungly is rendered today and Gamescraft is rendered after 6 months, probably the dice would have been rolled in a different manner, or the gamble would have been a different way. The outcome would have been a different way. Merely the Gamescraft is solely relying on Jungly. It is like doctrine of merger. It merges with Jungly literally. It says that, boss, something is there in Jungly. You will have to get the concept of Jungly here and then decide the taxability. So therefore, the premise exists on Jungly itself. So had the Supreme Court, or probably the SSC Council may not have been may not have anticipated as to whether the Supreme Court would draw the arguments from the Jungly to decide the Gamescraft issue. It is not solely on the Jungly issue, but the Supreme Court vastly relied upon the Jungly issue to decide the taxability and the GST implication of the actionable claim. Though the decision is interesting, but the last dice of the roll, the last card that is being shuffled, had this been after 6 months or 8 months, probably the outcome would have been a different way. To sum up with, I would just say that this is not the last roll of the dice, or this is not the last card that is being shuffled. Probably a review to the Supreme Court again can see the dicta in a wider scope with varying judges. Thank you. Thank you for the opportunity.
Thank you, sir. That was really insightful. Your views, and also uh, the detailed PowerPoint presentation also. So I think there are a lot of takeaways from this. And we'll open the floor for questions. If anybody has questions, you can raise your hand and we can take them one by one. Mr. Satish Sundar, sir, you can unmute yourself and ask our speaker the question. So please unmute yourself and ask the question, sir.
Dinesh,
Sir, yes, sir.
you are able to hear me?
Yes, sir. Yes, sir.
Very well presented. Well done.
Thank you.
This is what we require from youngsters. First of all, that I just wanted to ask if the Supreme Court had an occasion to go into the question of whether gaming is a game of skill or not, because that is one of the issues which had been consistently raised in all the cases which came on gambling, etc., online gambling, or earlier to that also, because that is age old. Just wanted to find out if the Supreme Court had an occasion to get into it.
Yes, sir. Supreme Court dealt with that elaborately in Jungly itself.
Yes.
They drew analogy that there is no distinction between game of skill and game of chance once you stake an amount.
Okay.
there is certainly a difference in the substantial degree of skill when it is involved. But the moment when you deploy something, money, a rupee into it, there ends the game, is what Supreme Court says. We don't care about whether it has substantial skill or only chance. It is only the money that needs to be looked into, is what Supreme Court says.
Okay, thank you. I just wanted to find out. Once again, well done.
Thank you, sir.
And we expect more such uh, webinars from you on various topics. Of course, we are in the process of identifying a lot of youngsters to come and join this platform. Once again, very nice. All the best and God bless. Thank you.
Thank you, sir.
Any other question from our participants? You can unmute yourself and ask our speaker the question.
A slide can be closed. Hi, Dinesh.
Hi, sir.
Good preparation and excellent work. I was wondering where is the Income Tax Act is missing. You have compared or connected GST and Income Tax Act. Well, good preparation, and you explained how parallelly Madras High Court and Karnataka High Court traveled, and how what are the issues before the Supreme Court. I think all the 6 questions you have tabulated and how it is decided. Well done, Dinesh.
Thank you, sir.
Any other questions from our participants?
Okay. In case we don't have any more questions, thank you very much, Dinesh, for a wonderful and very, very well researched presentation. So I can for sure say it's a game of skill to make a presentation like this and not a game of chance. We probably will have 2 webinars every month on a going forward basis. And we look forward to the participation of all members of the bar and more importantly, the junior members. Thank you.
Thank you so much, sir. Thank you.